Thank you very much. Just before we recommence the cross-examination and I hand over to counsel for the respondent, let me just note for the record that in the recess, counsel for claimant and respondents approached the tribunal jointly to indicate that they had discussed the issue of the introduction of a new document, and that counsel for the respondent was withdrawing the application.
Mr. President, may I just clarify? I was advised of the continued objection by counsel for claimants to the admission of the document, and in light of that continued objection, after they took a look at the document, we have decided to withdraw the application and to rely on the testimony given by Mr. Berkowitz without the benefit of the document.
Thank you very much, Mr. Alexandrov, and I simply remind you that our ruling in respect of the document as given yesterday morning then remains the ruling. Excuse me, just. Mr. Alexandrov, back to you.
Thank you, Mr. President. Mr. Berkowitz, we continue. Mr. Berkowitz, when you purchased in early 2003 the B lots, you registered them, and the purchase price that you registered for the purchase of the B lots was 500,000 colones for each. Is that correct?
I don't have access to the documents that you have in front of you, sir, but if you provide me those, I didn't do the registration, the attorneys did, so.
Okay, well, fair enough. I'll point you to the document.
Is it in my file here?
Yes, tab
Okay.
38. We have an English translation and then the Spanish document. You can look at the, if you will, the Spanish or the English, whatever you prefer. Which one are you looking at, so I point you to the page? Are you looking at the English?
I'm on 38, the first few pages.
Okay.
And
Look at page 2.
yes,
On top of it, I'm sorry. Yes, so if you look on the second page down, the 5th line from bottom, you see registration date,
yes,
9/22/2003.
yes,
And then 2 lines or 3 lines above that, you say, you see estimate of price 500,000 colones.
yes.
I submit to you that this is in relation to B1. We can verify that if you have any doubts.
No, I have no doubts in what you're stating.
Okay. Shall we go through the same exercise with respect to B3, 5, 6, 7, 8?
It's not necessary.
So you can confirm them that you can confirm then that lots with respect to lots B1, 3, 5, 6, and 8, they were registered or reported to the registry as purchased for 500,000 colones each.
Apparently so.
Okay. Let's talk about the administrative appraisals. You have received administrative appraisals with respect to each one of B1, 3, 5, 6, and 8, correct?
I believe so, yes.
Well,
Yes,
yes, okay. The administrative appraisal for B1 is 20 million colones plus. Is that correct? An amount exceeding 20 million colones. Is that correct?
I confer. That sounds accurate.
The administrative appraisal for B3 is 19,900,078 million colones. Is that consistent with your recollection?
Yes,
The administrative appraisal for B5 is over 20 million colones, correct?
Yes,
The administrative appraisal for B6 is 19,900,000 plus, so almost, just almost 20 million colones. Is that correct?
yes,
B8, it's in excess of 20 million colones, correct? The administrative appraisal.
yes.
Okay, and for the convenience of the tribunal, I'm saving some time here walking through the documents, but there are many documents, well, several documents in the record that I could point to. I think the easiest way for the tribunal to refer to those numbers would be Appendix 2 of claimant's reply, which for your convenience you can find here behind tab 8. I'm sorry, claimant's rejoinder, and it's behind tab 8. So if you want to refer to those numbers and have the exact numbers, which I have here and can read them into the record, but I don't think it's necessary because you have them. Mr. Berkowitz, 500,000 colones. Would that be about, give or take, $1,000?
That's correct.
And if the administrative appraisal is 20 million, give or take, in some cases a bit above 20 million, in some cases just below 20 million colones, then the administrative appraisal is about 40 times higher than the purchase price. Is that correct?
40 times higher than what the purchase price was registered
Yes.
on those books,
Is that correct?
of what you're stating, not the purchase price, but of 40 times higher than what you're stating.
Okay, well, let me ask you two questions in that regard. Let me ask you first, is it correct that the administrative appraisals are approximately 40 times higher than the purchase price that has been registered for the B lots?
The purchase price that was registered, as you're reading in the public registry, as was the tradition of that day, was to register at book value. The attorneys registered them at book value. Is not a fair rendition of what the purchase price of the property was, but they registered at that because that was very typical for Costa Rican attorneys at the time, to register them at book value rather than the actual value of the escritura.
Mr. Berkowitz, again, you're not answering my question. Whether the price registered in the registry is correct or not, my question is whether that price, the purchase price as reported to the registry, is about 40 times less than the administrative appraisals for each of the B lots.
I'm sorry, I object. My witness actually did answer has answered all of my questions, my friend's questions. And the 40 times is just an exercise of mathematics, and I don't want the witness to be confused between what we're multiplying. And I think the witness has actually answered, because my friend didn't restrict his earlier question, as I read the transcript, to as registered, because he asked both questions, and the witness was fairly answering both questions.
I think in the course of the questions and the answers, the point's been clarified. Thank you.
Mr. Berkowitz, my next question is following up on your answer. So you are saying that the price reported to the registry, well, let me not put words in your mouth because your counsel will object. You're saying the price reported to the registry is not the purchase price? Is that what you're saying? The actual purchase price?
That is what I'm saying.
And what was the actual purchase price for those lots?
$1,500,000.
$1,500,000 for each of the B lots?
No, total.
Total. Mr. Berkowitz, have you reviewed the report of the damages expert for claimants in this case?
I read through it. I don't claim to understand it. It's a bit above my pay grade.
Do you know, Mr. Berkowitz, sitting here, what the damages expert for claimants stated in their report as the purchase price for the B lots?
No.
Okay. When you answered my question about,
I don't recall. I'm sure I read it, but at this point, I don't recall. That's my honest answer.
understood, we'll take that
Okay.
with the expert. I asked you a question about 1.5 million, and you said total. Did you mean total for the 24 lots that you purchased in early 2003, or only for the 8 B lots?
My total purchase price for the entire property was 1.5 million.
So the B lots would obviously be a portion of that.
That is correct.
Okay. Could you turn to your first witness statement behind tab 3?
Could I ask for a short break? I was sequestered here during the break. May I take a short break? Please?
Yes, please do.
Sorry for the inconvenience.
we'll just wait for Councillor for the respondent. Mr. Alexandro?
Thank you, Mr. President. Mr. Berkowitz, so we established that 1.5 million was for the whole property, not just for the B lots, correct?
Correct.
Okay. Do you recall how much of that was just for the 8 B lots?
It was not a separate contract. It was
not a separate.
one purchase contract.
You sold B7 to Mr. Grimillion, correct?
Correct.
And you sold it for $425,000, correct?
In that range. I don't have his contract in front of me, but it was in the range of 400,000.
Well, I point
can't
to,
remember the exact number. It's in my witness statement.
it is in paragraph 15 of your first witness statement, in fact. So let's look at that.
Which witness statement am I in?
First one,
First
which
one.
is behind tab 4, and it's paragraph 15. So let's look at the carryover of paragraph 15 on page 5. So you have here, towards the end, you say, around February and March 2004. You see that?
Yes.
I sold 3 of my beachfront lots, lots B2, B4, and B7, in order to acquire funds to develop my other lots. You're with me, Mr.
Yes.
Berkowitz? And then you say I sold lot B2 for $425,000, lot B4 for $400,000, and lot B7 for $425,000.
Yes, I see that.
How many lots was the initial transaction for, do you recall?
Could you be more clear in terms of this transaction that you're referring to, or the total purchase?
I'm sorry, the initial purchase in January of 2003,
24 lots.
24. And here you sold, as you've testified, 3 B lots for a total of $1,225,000, correct?
Correct.
Okay. Please look at paragraph 20 of this witness statement, the first one. Could you read that paragraph into the record, please?
Our intention to develop the land, is that the paragraph you're asking for?
Yes, please.
Our intention to develop the land was finally barred by the issuance of Satana Resolution 2238 of 2005. The resolution suspended the environmental evaluation for all land located within the 125 meters inland. Therefore, I was deprived of building the home envisioned for me and my family in Lot B5, and none of the B lots that I had originally purchased could be developed.
Okay. Let's look at paragraph 46 of the same witness statement, which is on the last page. Let me read the first sentence into the record, and I'll ask you a question about it. You say in 2008, do you see that?
Yes.
2008, I was informed of the Supreme Court's decision by which, pursuant to Article 50 of the Constitution, it ordered MINAI to initiate the expropriation proceedings of the private property within the park and required it to pay compensation for any undue delay in the expropriation proceeding. You confirm that testimony, Mr.
Yes.
When in 2008 you were informed? Do you recall you were informed of the Supreme Court's decision?
I'm not certain whether I knew about it because it came in around Christmas, as I recall, and I believe I was on vacation, so I'm not sure whether I knew about it around Christmas or whether when I came back in January. But
Okay.
thereabouts, within that 30-day period, I knew about it.
Have you actually seen it and reviewed it, or you were just informed of it?
I was informed of it. It's in Spanish. It's a bit technical. I do read Spanish, but it is somewhat technical.
Were you informed also that that same Supreme Court decision also ordered a definite suspension of the environmental permits inside the park?
I was informed. I was so informed.
Okay. For the record, this decision is Exhibit C1J. Can we go back to your first witness statement, tab 4? The same
Which paragraph?
I haven't yet said
Oh,
that,
okay.
but I will.
I'm sorry. Thought I didn't hear you.
Tab 4, paragraph 46. Somewhere in the middle of the paragraph, we looked at the first sentence. You're welcome to look at the whole paragraph, but the sentence, the part of the paragraph I want to draw your attention to begins with however. And you say, however, it has been more than 6 years, and after having the title and possession of my property usurped from me, with a complete disregard of this ruling, and for that matter, the country's expropriation law, I was left with no alternative than to seek remedy through international arbitration. You see that?
Yes, I do.
And this statement is dated April 21, 2014. Correct?
Correct.
So when you say it has been more than 6 years, you're looking at 2008 or earlier, correct?
To 2014, yes.
Yes. Behind tab 6 is your third witness statement. Towards the end, paragraph 14. And you've testified in the first sentence why you did not file for this arbitration earlier. Because you are hopeful that the problems, the confusion and the problems caused by the 95 law would be rectified, correct?
Yes, I was intimately involved in an alternative proposal which we hope would solve everybody's problems and save Costa Rica the expense of expropriating and still protect the turtles.
Thank you. And this was the reason you've testified why you did not initiate this arbitration earlier. Correct?
As a human being, may I speak? As a human being, I find myself damned if I do, damned if I don't. I find myself in between a rock and a hard place. I came in good faith to Costa Rica. I did everything as I promised I would. I was prepared to do everything in good faith to protect the turtles. At what point do you know that the host country is not going to compensate you in a prompt and an adequate manner? At what point does that magical something light up and go, okay, I've got to go and spend a huge amount of money to go into international arbitration in order to be able to be paid? Because if you go too early, then you'll be coming back to me and saying, you didn't give the process enough time to play out, to mature. And so just at the same way that you're making a point is we came too late, we were also told that don't go too early. Give the host country a chance to show that they are, in fact, sincere and that we will get prompt and adequate compensation that will be treated fairly. So we're not big companies, we're individuals. And so you're asking me to respond to a question. I'm just coming from the heart. I'm just going to tell you how it feels. Feels like, how do you know when that magic time is that all of a sudden you throw your hands up in the air and go, hey, I'm paying taxes on a lot of money on these properties, and they're going to pay me $13 and some odd cents a meter for white beachfront property in front of white sand in this incredible environment, and that doesn't feel fair. That really feels inequitable. That really felt, and at that point, when it became clear that, it's when I felt that there was no good faith on the part of the host country to compensate us appropriately, that I finally made the decision it was time, as a last resort, to go international. It's a very expensive endeavor.
Mr. Berkowitz, when you say, and I'm looking in the transcript, quote, we were also told that don't go too early, give the host country a chance to show that they are in fact sincere. Are you referring to legal advice?
Yes. Extensive legal advice from several different types of attorneys.
Mr. President, before I engage in this line of questioning that I'm considering, I want to ask you, an opposing counsel, he seems to have waived privilege. And I wonder whether you will permit me to ask.
No, Mr. Alexandrov, I'm not going to take his statement now as a waiver of privilege.
Thank you. I'm glad I asked.
I don't know what any of that means, but
Don't worry, Mr. Berkowitz.
Okay.
That's just lawyers talking to one another.
okay.
That was not a question.
It's above my pay grade also.
It wasn't a question to you, Mr.
Okay.
Berkowitz. Mr. Berkowitz, as we established, you have received administrative appraisals for your B lots, correct?
Yes, I have.
So the B lots are now in what we refer to as the judicial stage, correct?
That is correct.
What this means is that you have objected to the administrative appraisals, and you are disputing now before the courts of Costa Rica the amount of compensation for the B lots, correct?
We did dispute up until the Y in the road when we had to opt for international arbitration. At that point, we were barred from disputing any further. And it's at that point that the final appraisals came in at $13 a meter after the Y in the road.
Okay, well, you're referring again to legal advice, but I'm not going to seek to understand what the legal advice is. My point is slightly different, which is you're no longer in the administrative process or the phase of the administrative process. The discussion or the dispute about the amount of compensation with respect to the billots is before the courts, wherever that procedure is, correct?
I agree with that.
Okay. And then would you agree that any suspension or delay or whatever you call it relating to the administrative procedure does not concern your billots?
I plead ignorance. I read that one of my lots is in delay because of a ruling by I believe the Controlleria, that they stopped everything, and I was reading a summary that it's in delay. I don't know if that's administrative or judicial. I don't know. But one of them is in delay, and then the rest of them are in judicial.
Which one is in delay?
I have to look at my witness statements.
Please do. And I'm asking about delay with respect to the administrative procedure. Maybe you can still look at your witness statement, but let me clarify the question. Any suspension of the administrative procedure after that was completed with respect to the billots would not affect you. Isn't that correct? Because the billots are now subject to a judicial procedure.
I plead ignorance of the law once again, sir. I believe that all the lots had administrative appraisals, and if that means that all the lots went into the judicial phase, then they are in the judicial phase. All I know is that in reading over, one of them was in Zombieland. One of them was affected by not going any further. It's no longer actively being pursued. And I believe it's lot B1, if I'm not mistaken. I believe that's the one. But that's by recall. And I don't know if that's I'm not trying to avoid your question. I don't know if it's in the administrative or judicial phase. But one of them was affected by the ruling that said nothing else till you finish these 13 points that was discussed yesterday.
Would you like a minute to consult your witness statement to find where you're talking about this?
I don't think it's on my witness statement. It's from recall. Or maybe it is on my, may I read it?
Certainly.
Okay. I'm sorry.
Mr. Berkowitz, I didn't mean to interrupt. You can still look at your witness statements, but I want to point you to tab, I think it was 8, which is a document.
Mr. Alexander, I think if you affording Mr. Berkowitz an opportunity just to recollect his memory from reading his witness statement, let's just give him a moment to do so before we take him to another document.
Mr. President, if I can be of assistance, I actually think my friend has a good idea because the status of the lots are shown on the document he was going to take the witness to. I don't object to that. I think that might
That's
be
fine. I would just like the
helpful.
witness to have the courtesy of being able
Yes,
to
of
read
course.
through without being drawn to another document.
I think it's B1, Counsel. On number 32 on page 8 of my witness statement, it says, since the second judicial appraisal of 2009, the expropriation proceeding has not moved forward. So it's kind of in Never Never Land, that lot. So I think that's the one I'm referring to, but I don't know if it's judicial or administrative.
I'm sorry, you're referring to
On my witness statement, page
the first one?
8, line number 32, first line on page 8.
I'm sorry, which witness statement?
It's B1, first witness statement.
Okay, paragraph 32?
Yes. And it shows the whole process that B1 went through, and then it hit 2009 and nothing. That would be consistent with what I understand, that there was some sort of a freeze subject to 13 points being fulfilled, of which 9 have been done.
Okay.
Anyway, nothing has happened on Lot B1 since 2009.
Okay.
Whether that's administrative or judicial, I will leave that up to the court to determine.
Well, the court will determine every issue in dispute in this arbitration, but let's focus on what you are saying, Mr. Berkowitz, and you are saying you're beginning this sentence, paragraph 32 is one sentence, and you're saying since the second judicial appraisal of 2009, the expropriation proceeding has not moved forward. So whatever you are testifying about as being suspended or in zombie land, to use your word, it happened after the second judicial appraisal, which
Yes.
means you understand that this is in the judicial proceeding, correct?
That would be consistent with what my witness statement states, yes.
Okay. And so to use your language, Mr. Berkowitz, none of the B properties are, again, I'm using your wording, in the zombie land of the administrative proceedings. They are all, again, I'm using your language, in the zombie land of the judicial proceeding, correct?
Correct.
I can take just a minute.
Please do.
Mr. Berkowitz, I still want to ask you to look at tab 8, which is a document submitted by your lawyers. It's appendix to, for the record, it's appendix 2 to claimant's rejoinder on jurisdiction.
We'd like to give the witness the large copy. It's easier to read.
Thank you.
It's in relation to your testimony about Lot B1. So if you find Lot B1,
Yes?
and you look to the right, the last box that has yellow and purple, the date is July 31, 2013, and the exhibit is R36. And you see the column says appeal judgment.
Yes.
So, Mr. Berkowitz, is it correct that at that point in time, you, through your lawyer, suspended the appeal that you had lodged?
My belief is, again, I'm not intimately familiar with the process that my lawyers followed, but my belief is that we opted for a Y in the road where we were forbidden from pursuing any domestic appeals once we opted to go to international arbitration. My belief is that that's the truth of the suspension here, but I don't know.
Yeah. And Mr. Berkowitz, just to be clear, I'm not asking you to give me a legal answer as to the legal grounds. My point is, to the extent that something was suspended on that date, whether it's an appeal or a challenge to the appraisal, The point is, it was the choice made by you and your lawyer in view of these proceedings. It was not a suspension by the government of Costa Rica. Is that correct?
That is correct.
That was my question. Mr. President, I have no further questions.
Thank you very much, Mr. Alexandrov. Mr. Copa?
That's good, because this seat was getting hot.
Mr. Copa?
No questions arising, Mr. President. Thank you.
Mr. Berkowitz, there may be a question from the tribunal, so let's just pause there. You don't have any questions?
Yes, I do have just a question, just to know how your lawyers were working on in Costa Rica. My question relates to if someone instructs you about the legality or illegality of property registration below real and effective purchase prices and the impact that this registration amount implies on taxes you had to pay for property. It's just a problem of if you were instructed or not.
This is a two-phase question.
Go
And
ahead.
the first phase was that, to answer your question, was that I placed myself in my attorney's hands, and the normal procedures in Costa Rica of the day were to register property sales at book value. That's no longer the case. It was kind of a tradition back then. And the second answer to your question is I voluntarily increased my valuations to be in keeping with the sales that I made back in 2004, which were in the 400,000 range. I believe that I valued my property, I filled out the forms and valued my property to the municipality at $450,000 per each lot in order to be in compliance with the sales of the other lots.
And next question is the payment, you went through bank transactions, cash, the money was coming from the States, American
Bank
States?
transactions.
From American States. Sorry, from a bank in the United States, or
I don't think
you had
so.
the
I
money
think
already in
I think it could have been a combination, but by recall, I think it was a bank from here.
From the States.
No, I think it was a Costa Rican bank.
Costa
I've been
Rica.
here
Here
since
means Costa Rica.
1991.
Okay,
Been here a long time.
okay. So you have accounts in Costa Rica where you
Yes,
place
I
your
do.
money. I mean, this is a foreign investment, so it's money coming from abroad, Costa Rica. That's what I'm asking.
All of my money came from my
Mm-hmm.
earnings as a chiropractor,
Okay, fine.
post-tax dollars.
Okay,
Yes,
thank you.
thank you.
Mr. Berkowitz, just a number of questions from me, just to clarify some points. The first one I don't think is really a question, but just to ask you to confirm, you began your testimony by stating that you do not dispute that Costa Rica has a right to expropriate. So I just want to be clear about that.
I don't dispute that Costa Rica is a sovereign country. I don't dispute that Costa Rica has the right to declare any property of public interest. I'm completely respectful of that. If they want to put a freeway through someone's farm, they have the right to do so. If in their wisdom they determine that expropriating 75 meters of my property is going to save the species of the bala turtle, then I certainly would not oppose that. I completely respect that right.
Thank you. You gave some evidence about your meeting with the minister in 2003, and counsel for the respondent, Mr. Alexandrov, took you to two letters from the minister subsequent to your meeting, which you indicated you were seeing, or at least paying attention to, for the first time. Can I just confirm that that was the first time that you had paid attention to those letters?
This is the first time I've seen the
That
letters.
you've seen those letters?
No less pay attention to them.
This may seem to be a strange question, but I'd just like to have a clear sense of what your answer is. You placed reliance on what the minister said to you in your meeting as you've recounted it. Is that correct?
That is correct.
Why did you place reliance on what the minister said to you?
He had good eye contact with me. He was a sincere individual. He seemed to be an individual of exceptionally good faith. We were both surfers. He came in with a passion to try and solve the dilemma of not costing his country, not putting his country into a position of having to spend a lot of money in order to expropriate property when it was possible that there was an alternative where all the owners would adhere to a zoning regulation and everyone could have their cake and eat it too. And I believe he fervently believed that that was possible.
I understand from what you've just said and from your testimony earlier that you believed the minister because it was a good meeting, a personal meeting. But from your testimony, he also indicated that he was not in a position to put anything down in writing, and you made reference to the directive, the minutes that came subsequently. So my question was really trying to elicit whether you felt that you had enough because of the personal dimension of the meeting, notwithstanding that there were going to be no formalities that followed, that you would rely on what he said.
I did. I chose to, and I own that. I chose to rely on what he said. I believed him. I proceeded in good faith. I saw him as an individual of good faith, very intelligent, capable. He seemed exceptionally sincere, and I am exceptionally sincere. And I just said, okay, I'm going to believe him, and I'm going to pull the trigger, and I'm going to buy this property.
You had no subsequent meetings with the minister. It's just this one that you've recounted in your evidence.
That's correct.
Just two then last questions, and this is really an attempt on my part to try and disentangle some of the aspects of the evidence that we've heard, and the entanglement may only be in my mind rather than anyone else's mind. I understood from your evidence that you are of the view that the expropriation of property only crystallizes, only becomes good, if you like, once the payment of compensation is made, once the process is complete. Is that correct?
I'm fervently of that opinion.
So in circumstances in which property is taken or diminished in value, but the payment has not been made, and I'm not asking you for a legal answer because the legal answer may very well be different, but it would be your lay understanding that the expropriation has not been completed. Is that correct?
That is absolutely correct.
Then in respect of the park, from your evidence, I understand you to understand, so I think this is a question of appreciation again rather than a question of law, that it is your appreciation, your understanding, that the boundaries of the park change as property is expropriated and added to it, and that therefore your understanding is that the properties are not part of the park until the expropriation is complete and the compensation is paid. Am I understanding your position correctly?
There are two answers. One answer is what the law 7524 states. The law 7524 states when the properties are expropriated, they become the park. And then there's the Costa Rica law of expropriation, which says expropriation doesn't occur until we're paid. So how do you reconcile those two? Essentially, that's why I'm fervently of the opinion that until we're paid, it is not, as you say, crystallized. We need to, the act has to happen, we need to be paid, and then everything else follows and the expropriation is terminated. The title can be transferred because we've been paid. We have not been paid.
I'm really just trying to clarify, and perhaps there is no clarification to be had, but of the exchanges that you had with Mr. Alexandrov, where he was taking you to the stamps, which indicated the understanding of the ministry that the property was part of the park, and your response to him was no, your understanding is that property was not part of the park. And I'm really just trying to understand whether your appreciation arises from your understanding that property only becomes part of the park once the expropriation is complete.
And that's what I've read and my attorneys have put in front of me in terms of my protection under Costa Rican law, is that I have protection. And that's exactly what I've read, is that exactly what you've stated. Until we're paid, the expropriation has not crystallized, and it's not a completed act, as I've read in this, and that absolutely that is my belief.
Well, Mr. Berkowitz, thank you very much. This has been a long evidence session on your behalf. The tribunal is very grateful indeed for.
Thank you. I'm honored that you heard me, and I've waited a long time to have my day in court. Thank you very much.
Thank you. May I just ask counsel for both sides? We have one more witness of fact on behalf of the claimant. I don't know where Dr. Rusenko is, whether he's
standing by.
He's standing by. Mr. Alexandrov, if we can complete that, if we can complete Dr. Rusenko's evidence today, and I appreciate that this may be asking how long is a piece of string, but it would be desirable to try and complete that evidence today. So the question to you is, do you think that you are likely, I'm not going to hold you to this, but likely to need more than the time that we've got before the end of the session?
Can we have a brief discussion with the tribunal and counsel of the record so that I can answer that question to the best of my ability?
Yes, please do. So we will suspend the session just for a few minutes and have a brief conversation.